I've informed Mr. Kappa. I've informed Mr. Kappa.
Oh, already informed.
Yes.
Okay. When do you want to see?
Can it be on Wednesday, man?
Next
Next Wednesday.
Wednesday. Okay. Mr. Dicky Pang, Rana Senior Counsel. Are you appearing on behalf?
behalf of the Tapak.
Okay. Rana Senior Counsel assisted by Mr. Tajo. Rana Counsel for the appellant. Praise for some accommodation and to be listed the matter on next Wednesday would be
26.
26
But
to which Mr.
Lordship, election petition is there for evidence, Lordship.
Oh, evidence. They take lot of time.
Then the next week thereafter.
Okay. Next week would be
Iduruli.
third. Then, oh, okay.
Fourth is holiday, Lordship.
Fourth is holiday. And the second or okay. Then May 9th.
Yes.
9th. Okay. To which Mr. Sibo, na?
Yes.
And counsel appearing on behalf of the respondent has no objections. Accordingly, the prayer agenda list matter on 9th. As requested, list the matter on 9th. Okay. Out.
May your lordship,
Yes.
your lordship, I'd like to mention unlisted matter. It's a criminal petition.
What is this about?
It's a criminal petition for quashing here.
My lordship, I beg to mention item number 5. It's a bail application. Your lordship, with the consent of opposite party, this matter may be fixed on Monday.
Why?
Monday.
Why?
Because the conducting counsel is out of station. It's a bail hearing, Your Honor.
On the prayer of Miss
M. Jarang.
Land Council appearing on behalf of Mr. Rajesh Arsana, Land Council for the petitioner, list matter on
Monday.
Monday. Okay.
May I please, Your Lordship? Item number 10.
Item 10. Yes. Who is for the other side?
I taken consent. He come to
You are for?
petitioners on behalf of K person.
Mr.
M person.
Land Council for the petition. But why you are mentioning? You have any urgent work? It is in order. The other side is present.
Yes, sir.
Where?
I taken consent.
Land Council for the petitioner. Staff. The appearance of the other party, other side has already been recorded. Has it come on record? Okay, the record reveals that the respondent has already entered appearance and also filed affidavit in view of the above, and let the matter be listed for admission after
2 weeks.
after 2 weeks. Okay.
Item number 1. May I, Lordship? Lordship is a bail application filed for releasing of the alleged accused person, namely Saiful Ali, who was arrested in connection with Dumporejo PS case 11/2026 under section 21A of NDPS Act. Lordship, he was arrested on 2nd July 2026. Today is 51 days he is under the custody, Lordship.
Offense 21A.
21A, Lord.
File bail application before the trial court.
No, Your Honor, actually, petitioner, they have some.
Why you have come directly?
financial constraint to move to Upper Subansiri. They are permanently hailing from the Lakhimpur, Lordship. They are only a driver. So they have some financial constraint to,
Driver has a capacity to move bail application before High Court.
since,
No capacity to move before the trial court.
since Lordship,
this is-
483, it is also empowered dishonorable court. There is no bar, so they approach before dishonorable court.
I think you should approach before the trial court first. Where have you stated that you have no criminal record?
Uh, In the last paragraph, page number 6, Lordship. In the last, it starts from, it's also submitted by the petitioner that he has no criminal anticipation regarding or in any other case. This is the first case, Lordship.
What is the punishment?
Up to 1 year, Lordship, and fine up to 10,000.
Lordship, they should have moved, Lordship, before
To
the.
move before
trial court is
before the trial court. Then everyone will come to High Court then. In that case,
Lordship, it's their choice to come since.
why it should be at your convenience? Advocate don't want to go.
No, Lordship, it's their choice, Lordship. I've already advised them to move before the lower court, trial court.
No mercy. You expect that the High Court will release because it's a smaller issue. Bigger court will give a concession. We'll reject it. You want the case diary to be called for?
Yes, Lordship. Since the 50 days is already, and mandatory period is 60 days, since it's up to 1 year punishment, Lordship.
Lordship, it's better that he should have moved before. Lordship.
Why you should be released on bail?
Lordship, I'm a driver.
Recovered from you, all information given, arrest. Everything is clear. Why you should be released? Twenty-one vials.
It's only 2.66 grams suspected heroin, Lordship.
Hmm,
And
so
up to 5 grams.
admittedly, it was recovered from your possession.
Not so clear.
All this, including the money. Hmm?
No, Your Honor.
Why you should be released for no reason?
Lordship, I'm already in 60 days. No, 51 days today.
51
Already.
days.
Yes. I was arrested on 2nd July.
After
Lordship.
60 days, if they fail, you apply before the magistrate.
Yes, that is there, Lordship. Well,
See, Rani Counsel, this is not the proper way it appears. Huh? Straight away, in such case, you are coming to High Court without approaching before the trial court. We'll have to make an observation later on while rejecting. Okay, when can the case diary can be produced?
Lordship,
on 20
Hard, Mr.
T Bagang, Lordship.
Rani Counsel, without any reason, see, you are coming, approaching the High Court straight away. And a case is also, it's a trial by the magistrate only, magistrate.
Yes, Lordship.
Then,
Yeah.
also hard, Miss El Hage. I think there is a order also that you should approach before the trial court. And then whether it notification that is there, no. Also, hard, Miss El Hage, and additional PP, huh? For the state staff. By filing this application, the petitioner. Petitioner is, who is the petitioner?
Mohammed Alauddin
Who is he?
is the uncle.
Claimed to be uncle of Saiful Ali, who has been arrested in connection with the Aforesaid PS case number 11/2026 under section 21A. Praise for release of the accused on bail in the aforesaid case. Staff. Issue notice. Call for the scanned copy of the case diary. Staff. List the matter
On 27, Lordship.
on 27. Okay.
Deeply honored. Item number 2.
Lordship, it's 27 is Lordship with early Lord. It made it Lordship on the 3rd of September, Lordship.
Third.
Yes,
Why?
Lordship. Lordship, this is Lordship, upper supposedly Lordship.
So what? It will travel by road. Scan copy.
So I'll try Lordship then.
Hmm.
Wait, Your Lordship.
Yes, sir.
My lord, this is pre-arrest bail application. My lord, this arises out of that border dispute filing that incident happened that we may village. Now, in the police report, as well as in the police report, the report that was submitted by the DSP, I am even not named. My name has just cropped up after these 2 days of ban that was imposed by the TMPK. When they issued these minutes, then my name crops up along with 3 others. My name crops up because I am about one of the only officers from that village. So they know my name. That's the only reason. I was not even there. My lord will kindly have page 19.
What is the FIR?
FIR is at page 20. I am a police officer, my lord. ABPS,
The FIR is inquiry report.
it's an inquiry report that has been treated as an FIR.
Okay, this has been treated as a FIR.
Yes.
No FIR lodged from the other side.
No, not here. Not here.
The FIR is there.
They have lodged an FIR in Gerukamuk that is subject to, my lord, whatever it is, because the incident, as per the claim of the Arunachal government, is happened in Arunachal Pradesh. They don't have any jurisdiction. That is another issue, man. That they will take care of.
Okay, FIR, they are also FIR.
There is
they have
an
lodged.
FIR in Gerukamuk. That is another thing. There is an application for bail that has been applied in Astambat. That is different. We are concerned with this. Your lordship will have the type copy at page 22. On 10th, I was not even there.
Claiming alibi.
My lord.
Claiming alibi.
That's why I was trying to point out at page 19. I was at Namsai. I proceeded to Namsai. I reached around 10:30. The incident happened here around 10 to 11. With due reference to this office letter, I hereby submitted forward annual performance appraisal report in our personnel and such and such. Namsai, Golden Platoon for the period such and such duly reported upon for further review such and such. This is on 10th when the incident took place. Everything will be on effort. If your lordship vote for the registrar maintained by the, because I am in the IRBN, it's a force. They have this, when they.
Now this
when they
inquiry
go-
report, on what basis the inquiry reports submitted, you were also present?
I'm not there. That's what I was pointing out, page 22. Inquiry report does not name me. The type copy. I had to approach your lordship because of the demand of the TMPK.
Demand of?
The TMPK, the
Okay,
organization who imposed
Okay.
the bond call.
what is their demand?
The demand is that I, along with 3 others, should be arrested.
Okay.
Not the 3 others.
Is there any allegation that you were present and then
No,
you,
they don't say that. How can they know? My lord will kindly have the report first.
Hmm.
In compliance of order number such and such, that the such and such, I have conducted an inquiry into the LS firing incident in Bhime village, where 8 persons from Assam reportedly got injured on 10th August 2026. During inquiry, I have visited the place of occurrence located near medical sub-center at Bhime village, Lower Siang district. So the place of occurrence is in Arunachal Pradesh.
okay,
During inquiry, I have examined Gauhati and villagers of Bhime village. During inquiry, I have ascertained the following facts and circumstances. Local meeting had been pending for amicable settlement for the plot of land, which is being used for common grazing of cattle for both Bodoti and Hime village. Bodoti is the village in Assam side.
okay,
In this regard, the Bodoti villagers proposed for a meeting at Hime village on 10/8/2026. But on the same day, there was a special
And in this village, Hime is,
in Arunachal Pradesh.
okay, Bodoti in Assam,
Yes.
okay.
But on the same day, there was a special intensive revision scheduled for Hime village as circle office at Kanku. So Sri Jarsam Ngomle, HGB, Hime village with document of SIR hearing visited the village of Sri Ramesh Dole, Gaupura of Bodoti village on 10/8/26 at 6 a.m. with the request to postpone the meeting since all villagers of Hime village will be away at Kanku CO office for SIR hearing. He even placed a proposal that meeting could be suitably held with 5 elder members from both sides, on which Sri Ramesh Dole agreed to postpone it. Meanwhile, 3 youth leaders of Bodoti village, namely Sri Bhovesh Lagachu, President Yuva Sangh, Sri Durgapur Lagachu, Secretary Yuva Sangh, and Sri Bittu Tayong, arrived at the house of Ramesh Dole. They aggressively told Sri Jarsam Ngomle HGB that they will not postpone the meeting. However, he returned to Hime village with assurance from Ramesh Dole that he would convince the youths to postpone it. On 10 and at around 9 a.m., Sri Ramesh Dole rang, that is the head governor of the Assam village, rang HGB Hime village informing that hundreds of youths of Bodoti village already left for Hime village in defiance of its advice. At that time, HGB was at CO office Kanku. Earlier at 8 a.m., Sri Udak Dang GB also called us Sri Ramesh Dole with same request to postpone the meeting. Later on, at around 9:30 a.m., nearly 500 people of Bodoti village and adjoining villages of Assam reportedly armed with lathi, dao, etc., and illegally stormed into Hime village and the reached and medical sub-center Hime village and started clearing jungle for the purpose of occupying the village land, and also damaged the medical signboard near government building. On getting information of this, Sri Mikken Gomde GB, who was at his house about to leave for SIR hearing in Kanpur, rushed to the spot to pacify the situation. He was accompanied by 3 villagers of Hime village whom unruly mob of Assam assaulted, and they escaped from the spot to save their lives. The unruly mob led by Sri Migom Megu overpowered the old Gaupura and took him to Assam for confining him. Meanwhile, some villagers of Hime, on receiving the information, resorted to firing on self-defense for protection of their lives and properties on being attacked by unruly mob from dangerous weapons. As a result, 8 persons of Assam got gunshot injuries. However, the accurate numbers of injured persons could not be confirmed as of now. During the inquiry, the PO is verified to be at a place in between Medical Sub-Center, Catholic Church at Hime village of Lower Siang District, Arunachal. During inquiry, the said inquiry, injuries to Assam have also been circulating in social media and news channels. The Assam police counterpart also informed verbally that some unknown person from Hime village had resorted to firing and inflicted villages to people from Assam. I will kindly note, the DSP says Assam police also says some unidentified persons. Hence, it is ascertained during inquiry that the firing incident resulting injuries in the sub-center had actually occurred. I therefore submit the inquiry for such and such. So this has been registered. I am named nowhere. Nobody is named. Now, your lordship knows there was 2 days of blockade of Arunachal Pradesh all over the state by the TMPK on 11th and 12th. Now, the government intervened, and these, my lord, minutes were drawn up. This is a press list. This I got from social media at page 26. Here they say there's the meeting has been held and all this, all that they are calling it off. But their demand at number 1, my lord will see the bold arrest of accused within 48 hours. The persons named by TMPK in connection with the alleged brutal attack at Badati village, Sri Nirak Nombe, that is me, and they named 3 others, must be arrested within 48 hours. That is why I am before lordship. The report suggests nothing. I am a police officer, my lord. It can be ascertained whether I was there or not. I made a category, I don't own a double barrel gun. And my lord, kindly note, the 3 others, my lord, has been granted clearance bail by the London Sessions Court at Pasighat.
Okay, so whether
So
you,
I am seeking for similar protection at this stage. I am
you
a
did
police
not,
officer.
you did not apply bail before session court.
No, I didn't do that.
Have you annexed
No, I have brought it, madam.
okay.
In any case, my lord, there is nothing on record. And balance of convenience in my favor, my lord. I am a police officer. Let the CDB call for everything will be there. If I have done anything, my lord,
Yes,
Yes, your lordship, CD may be called for your lordship.
CD would be required
Yes.
because the case already registered. This is based on the inquiry, and an inquiry, his name is not there.
Yes.
Mm.
Only on the demand of
yes. This is
union,
like
your
that,
lord.
What is the name of the regime?
मतलब हम ना हमको सितंबर तक है सितंबर फर्स्ट वीक तक नहीं रहेगा कर दो
And I am named basically because I am one of the only officers from that village. In fact, I have actively participated this so that these border disputes are settled. That is how they know my name. They have only named those persons who they know.
Whether this person, what is his name?
The applicant,
Nirak.
Nirak Mamle.
Okay.
But the investigation against me is very easy. I am a police officer. Everything is on record. Where I was there, because I am on law and order duty right now at Bolan for this Siang Dam issue that's going on there. Everything will be on record. Your Lordship will protect me till the next day. Everything will come.
Hard, Mr. Dicky Pango, Lana Senior Counsel, assisted by Mr. Tajo, Lana Counsel for the petitioner. So I've also had Ms. Jenny, Lana additional PP for the state staff. Para. The petitioner filed this application under section 482 of the Bharatiya Nagrik Suraksha Sanhita, seeking grant of anticipatory bail in connection with LKB, Likavali PS, LKB stroke PS stroke FIR number 38 stroke 2026, registered under section 117 2 stroke 3 within bracket 5 of Bharatiya Nyaya Sanhita 2023, read with section 27 1 of Arms Act. Start. Pat. It is submitted that based on the inquiry report, submitted by the DYSPH Lower Siang Likavali. A case has been registered. The aforesaid case has been registered. Start. The Learned Counsel for this petition submitted. In the inquiry report, the name of the accused is not, the name of the accused did not find any place. However, based on the press release issued by EM Takam Missing Porin Kebang within bracket PMPK, allegedly demanding the arrest of 4 persons from Arunachal Pradesh, including the present petitioner, Kama. The police has issued notice upon the petitioner under section 35(3) of BNSS requiring his attendance. Before the police start. The Learned Counsel for the petitioner submits that the applicant is the police officer having posted that where
Namsai.
Namsai.
Namsai right now on duty at Pangin.
Namsai
Extend
and
Commandant
presently performing duty at
Pangin. Siang
Pangin.
District,
okay. Start
for the Siang Dam.
for the Siang bed. For the Siang?
This Siang Dam issue is
Okay,
going
for
on
the
law and
Siang
order.
bed, okay. It is submitted that although on 10/8/2026, he have been to his village.
No, on 10th, I started at early morning and reached Namsai at 10:30.
Okay,
I was
on
not at the station.
10/10/2026, he started from
From Hime village
Nivea village
in
To-
early morning,
early
reached
morning
Namsai at 10:30.
and reached Namsai at about 10:30. In connection with what?
My lord, by kindly at page 19, the
Hmm.
submission of the annual performance appraisal report.
Okay.
This I have intimated to the
Okay,
commander.
for the submission of annual performance report to in compliance of message, in compliance of WT message
Yes, WT message is your lordship will find at page 18.
that dated
This is dated
second
15/7.
15/7.
15/7/2026. However,
Oh, 7/8/26, my lord.
7/8/2026. And thereafter left that place on,
From Hime, my lord, in early morning, 6:30. Okay?
no, after Namsai then, thereafter,
After Namsai, I went to Siang, Pangin.
okay, thereafter, we went back to Pangin. However, he was not present in the place of occurrence where the alleged incident took place. Stop. The Learned Counsel for the petition further submits that he is nowhere involved in the aforesaid case, incident. However, since the police has issued notice requiring his appearance, he has a reasonable apprehension that he may be arrested in connect on the pressure under pressure of the pressure of
DMPK
uh,
to impose blockade.
the DNP DMPK group. Stop. Hence this pre-arrest bail application. Stop. It is submitted that the applicant is ready to cooperate and appear before the police and to abide by any terms and conditions that may be imposed by this court. Stop. Miss Jeannie, line addition P2. Summary states the fact whether the applicant was present on at the time of incident on the spot or not would be clear from the case diary. Therefore, in the instant case, the case diary would be necessary for consideration of this pair staff. In view of, therefore, she prays that she may be allowed to produce the case diary. So, in view of the above, this court is of the view that the case diary would be necessary. The result of the case diary would be necessary for consideration of the bail prayer of the petitioner. Accordingly, call for the scanned copy of the case diary. Stop. List the matter again on
31st, Your Lordship.
Hmm?
31st.
31st. Stop. In the meantime, pending production of the case diary, in the event of the applicant being arrested in connection with the aforesaid Mikavali case number 38, 2026, he shall give his name, huh? What is his name?
Nirav Gomble.
Gomble being arrested, huh? In connection with the aforesaid Mikavali case number 38, 2026, he shall be released on interim anticipatory bail on furnishing bail bond of rupees 50,000. How much they have?
Madam,
Okay, this we have not referred, huh? We have to refer one line also. How much bail amount? Yeah,
there's my daughter,
50,000 with one surety of like amount to the satisfaction of the arresting authority, subject to the following terms and condition. Okay, that's the applicant shall cooperate and appear before the eye of the case within 10 days from today to give his statement for examination, for his examination, and thereafter, as and when called for stuff that next time that the applicant shall not influence any witness just a normal course. Where is CRPC? Okay.
The two conditions to suffer.
Not that the applicant shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case, that the applicant shall not he is in service only. Okay. Okay, that's all. That's all that he shall not
Movement would be
tamper or
difficult.
tamper with the evidence of the case in any manner. Okay. Please the matter cannot transfer.
Right.
Okay.
Problem.
One, one sentence that the other accused person has already been granted will also be recorded.
In any case, my name finds me.
Hmm.
There's no way.
One way in the other, in submission of the petitioner, that Lara Council for the petitioner submits that in the similar situated case, the in the same case, the other co-accused whose name name other co-accused person has already been granted. It's a bail or anticipated bail?
Anticipated.
Okay, anticipated bail by
No,
by the
the latest session.
by the Lani Session Judge Pasigat on 18/8/2026. Oh,
Open.
Item number 3.
yes,
Lordship, this criminal petition for
yes.
FIR and charge sheet. So FIR was registered on 2010/2023. It's in page number 28.
Page 28.
Marriage.
Okay.
That's one thing. That's one issue. Okay, the first thing with regards to the ordering of FIR. Other thing to our children in the for not paying fees for rental of four cars provided on hire with the company. The gift the physical and given is bad. During October 2021, I have approached by the person of the operator of the market. It's his wife. Yes, his wife. The price. Then, proposal provide free number of 10 legal number of direct lease, therefore, controlling them with finding them net of service with private limited with subsidy. Here is it. For a figure of 5 years, as the term and condition. That's given in the break it and take it with you. Now, under 51, the work order figure. 80 of the 50 by using minus in since every time I have one penny in the book, I bought 3 more instead of the mail in the books. I taking out the next year about the simple to beyond interpret that we make our first week of June 2023. Work with UP Highway and network service. You will get just part of the UP. There are the street services. Of course, we provide one more thing with of course. It's actually about one data number, which was working currently on a contract and send it to work with other companies first week of January 2022. That will take however long then it was late. I then so get the price for directly by binding the estimate for mobilization of the dumper or analysis once the test of the agreement if we can it will be known maybe the same by during the February to April 2023. Streets for the person gave me for a delivery. And finally gave a check of check to his structure and fixed promise. Same way, control from the finally on payment. One payment has been whether at the 28. Thereafter, gave the established in the facility. Hence, I approve the limited to give me a work of the IT so that payment would be made. You may without going to the request. The same was agreed to be by way cemented work order. Here, Lordship, it says that the complainant has approached the company of the accused person, the petitioner, directly approached for the work order. There was no inducement from the part of the petitioner. The FIR says that here the complainant was approached. You did keep delaying payments on one certain text or other, and only partial payment can make to you, and then people I stop my vehicles and completion. Understanding the needs of their civil the vehicle, running in order to the plant application, I keep up. Working with them, in turn, first and second, getting nice, with thought by sending force transaction missing, and took advantage of me being in simple driving. He was helpless and not attended option that by get my payment is. I didn't have series. Along with the and you might take it. And he promised that all 20 days will be here the next 15 days, but that didn't happen. Since my life is back now, account the tenant of PMIs that they want the regular servicing replacement of tires, payment of tires and first. I had no option but to approach the honorable minister to any of the president regularly and sitting in the right government. I met him twice, wherein for a teacher after leaving Wara, he said that all my views will be clear within the next 15 days, but that was a huge false commitment. Since my tenant and liabilities and tenants being conveyed cement, a term of this contract rights kept increasing every month. I was left with no other option but to immediately withdraw my vehicle on 31 March 2023 to avoid further notice and engaging with demand and which was giving me into depression. Not having not posted and say. Thereafter, I have to address you to bank the registration. This is the case.
Yeah, how much amount he was to pay, say?
Their claim is 85 lakhs.
35 lakhs for what?
For 85 lakhs for rental of the vehicles. Now, Lordship, the work order which was given to the PTK enterprise. This is
Work order was given by?
by the JUD Cement petitioner. Petitioner is the MD and managing director of the JUD Cement.
Petitioner has given work order.
Company, JUD Cement company has given the work.
He is a
He is the
general manager,
managing director.
managing director of the company.
Yes.
He gave work order.
Work order to PTK Enterprise. There was an agreement between PTK Enterprise and the.
Who is this PTK?
He is a third party.
Okay,
He is not involved in the case.
okay, then?
After that, the PTK has approached the form of the complainant. PTK Enterprise
Okay,
has approached the form of the complainant for vehicle. Now
for what?
vehicle for the
Okay.
number
Okay.
service,
Mm-hmm.
rental service.
Hmm.
After that, when there was dispute with the payment, the
The vehicle was given,
yes to the PTK Enterprise.
PTK, not to the present.
Direct, not to the company. There,
Hmm.
the company has no agreement with the complainant and
Okay, okay, the agreement is in between the complainant and the PTK.
PTK
Okay,
Enterprise. Now, after there was a dispute with the payment, the complainant has approached directly to the company,
Hmm.
the petitioner.
To release the PTK,
Not the PTK, directly to the JUDC.
whereas the agreement is with PTK.
Yes.
Okay.
Now, after that, a work order was given to the AS enterprise, which is the form of the complainant.
AS Enterprise is the
Enterprise,
complainant.
Form, yes, form of the complainant.
Okay.
After that, the AS enterprise has given service of vehicle to the petitioner's company.
Okay. No, directly,
Yes, like
not to the
Leading-
PTK.
PTK enterprise.
Okay. Okay. Then
Now, the matter has been charge sheeted under section 420 and 406.
no. What happened thereafter? What is the claim of the the
Now, after that
complainant?
complaint, after that, we have made some payment in the
Directly to the
directly to the AS
complainant.
complainant.
Okay.
Last payment was made in the made on 29/12/2022.
Okay. How much was the amount to be paid? 85. 85.
They are claiming 85.
Okay.
Paid 80,000,
Okay. According to you, how much is how much
This
remains
is the amount we have paid.
and how much amount remains?
There is no, this is the amount which we are saying that the number of days the work has been done.
The entire amount, according to you,
Ah,
have already paid.
yes. Now, if there is any issue, we are claiming that if there is with a proper bill is submitted, we are willing to make any payment.
Is there any communication in between regarding that you submit bill if you are claiming?
The-
Have you annexed?
File this FIR and make the entire civil dispute in the
Whether after filing of the FIR also, is there any payment?
no payment after FIR.
Okay. And then in between any
Communication,
correspondence, communication?
we are ready to communicate. There's
No. Have you communicated?
No, no. We are ready if estimate and proper bill and other it can be submitted. We can, if it's legitimate, we will pay.
Whether in the complaint?
Yes.
What was the PTK? What
Now,
was that?
PTK is no more involved in this case.
No, PTK, there is no allegation against PTK.
PTK, no logic.
Now straight away to the.
JP is made
Mhm.
by AS enterprise. Form of the,
Any communication notice demanding the release of amount prior to lodging of FIR?
communication prior to lodging of FIR, they were claiming.
Okay, what was your reply? Is there any reply to that?
But even notice was given to us, possibly page number. Number 37.
No, this is to investigating officer.
This is the reply of petitioner to the IO,
Reply of what? Reply to what?
the notice
Notice given to
to the petitioner, 41 notice
by whom?
by the investigation.
Okay,
Should-
requiring his attendance. No, what I'm asking is whether the informant has given any notice to you for release or payment of the amount, liable amount.
There was communication,
What is the last communication?
no proper written communication, we have no written communication.
Yes, sir. Is it not a civil case,
Not up.
civil dispute?
I'll satisfy your lordship with the contents in the FIR, your lordship. Your lordship will have taken the note of the entire
So
paper.
what is the stage of the case? Charge sheet filed,
Yes, a trial is going on, your lordship.
trial is going on,
Yes,
evidence recorded,
The entire record is not available before this court. Only the record till 1st of January 2025 is there.
Okay,
Order
so
shows.
how many prosecution witnesses so far have been recorded?
That's not in the record, Your Lordship.
Not in the
This
record.
record had come way before where the first PCR was called for. I'll just take Your Lordship to certain points in the FIR, Your Lordship. The gist of the case being that Your Lordship is well aware that there was two party, Your Lordship. First, JUD, that is the present applicant's company, Your Lordship, cement company, had a deal with TMK, Your Lordship. TK Enterprise. PTK, Your Lordship. Now, both of them, now during their agreement, the vehicle of the complainant was used, Your Lordship. They hired the vehicle of the complainant.
What is the name of the farm? Complainant farm?
AS and
AS?
AS. Now, PTK and JUD, during their term of agreement, had an issue for non-payment of the bills, Your Lordship.
Who?
The first party, that is the PTK, Your Lordship. There was a first agreement between both JUD, accused company, as well as the first party, PTK, Your Lordship. They had an agreement for supply of certain thing, Your Lordship. The vehicle of the complainant was used during that period of time, Your Lordship.
During the?
Period of time when the agreement was there between the PTK and JUD, Your Lordship. Now, during that time,
No. During the PTK and?
PTK is the company of a third party, Your Lordship, who had the first agreement with the JUD, Your Lordship. JUD is the company of the accused. Now, the enterprise, the firm of the complainant is AS Enterprise.
AS.
AS Enterprise. Now, the factual matrix of the case is that first there was an agreement between JUD, that is the accused, and the third party PTK.
There was agreement between them also.
Them also. First,
Prior to the agreement between PTK and AS.
yes. No. PTK and AS never had an agreement.
You
JUD
said that PTK and AS had agreement.
first agreement was between JUD.
No, he also say that there
No,
was
no,
an
no.
agreement between
No,
PTK and AS.
that's wrong. First agreement is between JUD and PTK. Your Lordship will record that PTK is a third party, Your Lordship, in the FIR, Your Lordship. The first agreement was between JUD and PTK. They had a business between them for supply, and the vehicle of the complainant, that is AS Enterprise, was used by the PTK. Your Lordship has got it, Your Lordship. Your Lordship has got it, Your Lordship. Thereafter, they had PTK and the JUD had an issue with regard to non-payment of bills, and the agreement was closed between both the parties. Subsequently, the complainant approached that since you are using my vehicle, let me direct be the party to your agreement. Let us both get into an agreement and start the business. Now, the second agreement was done between JUD and AS Enterprise. That is the company of the accused as well of the complainant. The issue started when the agreement was done, Your Lordship. After the agreement was done, all the supplies were made, the vehicles were used, the bills were not paid, Your Lordship. Now, Your Lordship will see that even though the complainant had made an approach for the proposal of a business of supply, Your Lordship, the applicant herein also agreed for the business, and both of them came to an agreement. Now, interestingly, if I may take...
JUD and AS.
Yes. Subsequently entered into an agreement. Your Lordship will find at page
Now
number
PTK
20.
eliminated.
Your Lordship will find at page number 25. I'll just... 29, Your Lordship. Fourth paragraph, Your Lordship. Thereafter, JUD
No.
Cement,
No, wait.
29, page number 29. If I may read, Your Lordship, para number 4. Thereafter, JUD Cement stopped responding to Tarsem Jindal, who is the MD of the PTK, Your Lordship. Hence, I approached JUD Cement Limited to give me a work order directly so that payment could be made to me without going through PTK Enterprises. The same was agreed to by JUD Cement and work order was issued to me. I'll just stop here, Your Lordship. Thereafter, the payment was not made, Your Lordship. Then I'll take Your Lordship directly to page number 36, the relevant portion in the charge sheet, Your Lordship. The relevant portion, I'll start with alleged accused, Your Lordship. The first line,
Page?
page 36, is a relevant portion of the charge sheet. Your Lordship. I'll start with alleged accused. Alleged accused person Sri Adarsh Junjunwala, being the director of UD Mining Network Service Private Limited, did not inform the complainant about the shutdown of his factory and kept the vehicle retained under the company. To this, Your Lordship, I have flag marked the statement of the accused in the trial court record, Your Lordship. Your Lordship will see that when the complainant has approached the present applicant, that is the JUD Cement, Your Lordship, what he did is he did not inform the complainant that his company has been closed. In fact, what he did is he accepted it, issued a work order, took all the benefits out of the vehicle of the complainant, Your Lordship, never informed about the closure of the company, Your Lordship. And when it was time for the payment of the bill, Your Lordship, even at that point of time, it was not disclosed. I flag marked it in yellow in the TCR, Your Lordship. In the trial court record, Your Lordship, that is the statement of the accused, Your Lordship. There are two TCR, one.
Statement of accused.
Yes, Your Lordship.
Sorry. What is this?
Your Lordship, to my submission, I would like to place this record, the authority, Your Lordship, in terms of cheating from the very inception, Your Lordship. At page number, Your Lordship, down below, we'll find page number 6, paragraph 16. In this case, when the property was initially mortgaged, it was not disclosed to the parties, Your Lordship. I'll just read paragraph 16 and 17 is the relevant paragraphs, Your Lordship. From the submission made by the learned counsel for the respondent number 2, it appears that At the time of entering into the argument, the petitioner had already mortgaged the property with LIC Housing Finance Limited for obtaining a loan, and notice has been issued to them as defaulted. This material fact was allegedly suppressed from respondent number 2, who was under the impression that the land was free from all encumbrance. Therefore, it cannot be viewed merely as a case of breach of contract simpliciter. Rather, there appears to be a prima facie intention to deceive respondent number 2 at the very inception of the agreement for sale. While these facts may be further examined during the trial, but from the contents of the FIR, they are found a prima facie case against the petitioner. Furthermore, as held by the Honorable Apex Court, the mere availability of civil remedy does not warrant quashing of criminal case, where the allegation disclosed commission of a cognizable crime. The Honorable Supreme Court in Vesa holding so-and-so, reported in so-and-so, has held in paragraph 12 and 13 of the said judgment as under. From the decision cited by the appellant, the settled position of law is that every breach of contract would not give rise to an offense of cheating, and only in those cases, breach of contract would amount to cheating where there was a deception played at the very inception. If the intention to cheat has developed later on, the same cannot amount to cheating. In other words, for the purpose of constituting an offense of cheating, the complainant is required to show that the accused has fraudulent or dishonest intention at the time of making of promise or representation. Even in a case where allegations are made in regard to failure on the part of the accused to keep his promise, in absence of a culpable intention at the time of making initial promise being absent, no offense under section 420 of the Indian Penal Code can be said to have been made. It is true that a given set of facts may make out a civil wrong as also a criminal offense, and only because a civil remedy may be available to the complainant, that itself cannot be a good ground to quash a criminal proceeding. Thereafter, also, Your Lordship, at paragraph 18 and 19, I won't trouble Your Lordship to this fact, but the facts remains that at the very initial time of when the work was shot, Your Lordship, his company had closed, which was not even revealed to the petitioner, complainant, Your Lordship. She was kept in blind to the entire fact of the closure of the company. She was, all the vehicles of her were used, works were initiated by the by JUD, the applicant herein, without even informing that the company has closed, Your Lordship. That's where the cheating comes.
Just a minute, one clarification.
Yes.
You said that last payment was done on
29 December 2020.
2022, when the company was closed.
Company, after the company was closed, this is the last payment. And on,
After the company was closed.
yes, and on March of,
No, just a minute, company closed on?
it's still, there was some difficulty. Temporarily, the company was closed.
On,
Exact date is there.
okay. But
Payment has been made. But if it's in the
when?
charge sheet there. On 29 December 2020.
2022?
Yes.
When the FIR was closed?
FIR was on 11 October 2023.
And the complainant has withdrawn the vehicle on March 2023. After the last, actually, 2 months after the last payment, she has withdrawn the vehicle.
When?
2 months after the last payment, on March,
Last payment was okay, March.
March of 2020.
Vehicle drawn, withdrawal means?
Lordship, though vehicle was on rental, the petitioner was never in fully under the custody of the petitioner. The drivers and helpers were all,
No, entire vehicle
yes,
withdrawn
yes,
on March. Okay, but then the payment remains prior to date only,
it's in the
up to 31st.
FIR itself.
Okay,
Last payment was made on December 2022 and on March 2023. Now,
no, in between, whether from March 23 to October 23 till the lodging of FIR, whether the AS has made any claim
Lordship, there has been claim, but no proper bill or no proper, claim has been
Have you indicated by any letter communication that
no
proper bill? Then you had an intention. You had an intention, that means
No. Lordship,
why you kept silence despite of demand
demand of lordship.
demand of payment of the,
Lordship, we are willing to make a proper legitimate claim.
that is why you said that they made a demand thereafter after last payment also.
Yes.
After withdrawal.
No proper bill or.
No, that is why, have you communicated to submit, asking the complainant to submit in proper bids? Where is the last one?
Verbally, since they have verbally communicated, we have also verbally.
There is no written. No written.
And
They are ready. Why no communication, and then could have been easily
They're
solved,
ready
but
only because an FIR has been filed against them.
the whole.
Your lordship will see that throughout the entire, your lordship has rightly pointed out, in fact.
see,
company-
the
company running-
last payment, it appears, was made 29/12/2022.
Mm.
Thereafter, whether the complainant has made any demand for payment?
Your lordship, as per the FIR,
No.
there is
The- I'm asking, before lodging FIR, any communication, any letter demanding for payment to the
No,
accused company?
we don't have as of any communications right now in written.
Okay, then,
No,
Ah.
but your lord, you have to
If your
point out.
lordship will allow your lordship, I would like to add one point to what Leonard.
Mhm.
Your lordship. The very fact that the petitioner had issued checks with checks pertaining to the accounts that had no fund in it, your lordship, that amounts to cheating.
check issued when?
If your lordship comes at page number 31, your lordship, annexure 2,
Which check? This,
list of seizures.
This.
just a minute. Just a minute. 31
Yes, your lordship, at page number 31,
of the petition,
yes, your lordship,
annexure 2.
annexure 2.
This is a final police report.
List of, these are the seizure list, your lordship, the checks that were seized.
No, 31 is not a seizure list.
No, your lordship,
31 is the final report.
final report.
Consisting the Caesar
Seizure
made.
list.
At serial number 9, your lordship will see these are the things that has been seized. your
Seized,
lordship.
and all of the checks that has been referred here has been bound, your lordship. None of the,
Then there is then you have a remedy for that. If
Then-
check bounce case.
the fact that the petitioner had not informed us about the closing of the company, your lordship, and also the fact
No.
that the petitioner.
No. The check, if you says that the check bounced, have you lodged complaint
Yes, your lordship, and also,
under NIA,
yes,
negotiable instrument?
yes,
That case is separate, is
That-
pending.
yes.
Separate case is pending against the accused
No, your lordship,
under NIA, no.
under this act, your lordship, under this FIR. It has been
Okay,
registered under,
but then no separate
no separate. file.
complaint lodged for
No
check
separate-
bounce.
Yes,
Should have,
but then your lordship. The,
where do we find that check bounce?
at the list
where-
of the seizures, your lordship,
Number 31.
31, property description, serial number 1. There are 9 checks that has been issued, your lordship, by the petitioner. And if your lordship goes through the description, your lordship, all of the checks has been referred as bounds, your lordship. None of the,
No, there is a remedy, separate remedy for that check bounce case. NIA, under NIA.
yes, your lordship, but then your lordship may also take into consideration that the fact that the petitioner has issued this.
No,
check
so,
without
but
money in it, your lordship, only with the intention of cheating the complainant, your lordship. And the last payment was, there has been a payment only made once, your lordship. And rest of the
when that once?
that it was in the year 2022, your lordship.
29/12.
7 April 2022. That is my categorical statement, your lordship.
Okay, but the payment, what he is stating that on last payment is on 29/12/2022 is in by way of check.
No,
No, your lordship.
lordship, they have been mistaken. The check was never issued to the complainant. These checks are to the PTK enterprise. That is a separate issue. PTK enterprise not a party in the case. If trial court record, it's in the trial court record.
Now, why don't you contest that before the trial court then? It will be difficult for them, according to you, to prove case against you. Why didn't you stand trial? Because it's a question of trial only. Why do we try? Why the High Court should go for that?
Lordship, this is a civil dispute, Lordship. Only payment of, non-payment of.
See,
And
there is an
no
allegation.
intention to cheat from the inception. The complainant approached the petitioner, it approached the petitioner willingly, quarter or quarter. So there is no inducement. For cheating, inducement is necessary. There was no inducement since the complainant has approached the petitioner for the work. There was no inducement. And since they are claiming the check was never issued to the complainant. Check was issued to PTK Enterprise, which is a different issue.
It appears that they will not be able to stand with this stand because cross-examination, that thing will come, everything will come up. And then I think if you think that there is nothing against you, then they will not be able to prove. But then why this? There was no
No,
communication.
Your Lordship,
Last payment was done.
there is,
There is a separate,
there is, there
they
is
could have,
another-
just a minute, they could have lodged separate complaint under NIA for check bounce.
Yes.
There is a remedy for that. And then the last payment was done. Thereafter, you said that no communication. And now also they are ready. If they
being ready is.
they
not
file a
issue,
proper
Your
bills,
Lordship. If Your
etc.
Lordship then come to page number 29 again.
Then how it becomes a criminal?
I'll come to that, Your Lordship. If Your Lordship, we come to page number 29 again, Your Lordship.
Sorry. Yes.
If I may take Your Lordship to paragraph 4 again, Your Lordship. The highlighted part which starts from Mr. Adarsh Junjunwala.
Highlighted. Okay.
Highlighted part.
Hmm.
Mr. Adarsh Junjunwala kept cheating, telling lies, doing fraud by sending forged transaction receipt and took advantage of me being a simple trap. Who was
This is
helpless
only
and-
allegation.
No, who was help and did not have any option to get my payment release. I even met others along with Sri Tarsem in July 2022, and he promised that all pending dues will be cleared in next 15 days, but they did not happen.
No,
Now, Your
thereafter is it
Your Lordship,
29/12,
Your Lordship,
2000.
Your Lordship, just let me finish,
Say
Your
it.
Lordship. I'll take Your Lordship then to last paragraph, that is enclosed details, Your Lordship. Details of payment received from JUD Cement from PTK Enterprise.
Where?
That is
Page.
page number 29, Your Lordship.
Mhm.
The first is the detail of the payment made to the first party, Your Lordship. Page number 30, Your Lordship will see. B is the approximate statement of dues to me from 1st January till 31st March after accounting for payment received. Image of forged transaction receipt sent over WhatsApp by Adarsh Junjunwala. Details of bounce check. Now, there are images also which was submitted to the investigation officer of the forged transaction receipt, Your Lordship. Many things have happened, Your Lordship. There's not a simple
No,
case
no, no.
of civil.
What is this? What's up? You have never made a claim saying that this much amount you have to release.
We have,
Please release.
we
Never
have, Your
came.
Lordship. We have, Your Lordship.
Where? So the court, only one letter.
Your Lordship,
You made a claim.
when I made a claim, Your Lordship, the entire claim made by the complainant is itself is in the record in the FIR, Your Lordship. If Your Lordship will see, if I had not made a claim, would there be a transaction received from the Adarsh Junjunwala, Your Lordship?
See, after last payment made on 29/12/2022, and then if you think that you are still, the complainant, still some more amount to get, then could have you approach by way of writing, and then he's still ready, saying that he's ready, provided you properly prepare a bills. Isn't so?
And the FIR which they have read, June, July, they have approached. And after that, I had made payments on 10 of October, 28 December, 29 December, and 29.
This, I think, is a civil nature, case of civil nature.
Your Lordship will see
It's a
that
demand
payment,
not made, and then you want that the criminal court should,
yes, Your Lordship. Your Lordship.
criminal court should compel the respondent to pay
No, Your Lordship. Your
for
Lordship
fear
will
of
see-
going
Your
going
Lordship will
jail.
see
That
when-
cannot be.
No, Your Lordship will see when a party goes for a civil case, Your Lordship. It's always for getting the amount back, Your Lordship.
See,
When it's a criminal case, the amount need not be paid back to me, Your Lordship. But then something bad has happened to me and therefore we approach the criminal court.
here is the case where you approach and then the agreement entered, when the person entered into an agreement, it's a civil only. Okay, there is a remedy.
Yes, Your Lordship.
And then thereafter, somewhere, some failed. Thereafter also, the last payment was made. And after last payment, if you think that still more, you are yet to get the complainant. If the complainant think that they are yet to receive more, something more, could have written,
Your Lordship may not
and
lose.
he's ready now by saying that this much amount out of this 85, this much amount paid, this much amount is yet to be paid, kindly pay.
Your Lordship,
And in that case, if he play a fraud, different. But then if he is ready, no criminal case appears to have been made out.
Your Lordship may not lose out of the sight that till the FIR was filed, there was no information against closure of his company, Your Lordship. Now,
But
when
still, see,
now-
company was closed on when you said,
their own statement, does not know when the company was closed. It was on,
But still, company is still there. Temporary closure was there. Now it's still working.
that is not
See-
that is not in the investigation statement, Your Lordship. Your Lordship will clear. Therefore, I had taken Your
see,
Lordship to state
I don't know where the company, according to where when the company was closed.
that. Therefore, I'm saying, Your Lordship, even the complainant does not know the company was
We do
closed.
not know. But then last
But-
payment was made on 29/12/2022.
Your Lordship, even the company is closed, not closed, my payment has to be made to me. That's
Yes,
a
yes.
different thing.
Yes,
Your
he's
Lordship,
ready, he's ready.
Your Lordship, no, that ready is, Your Lordship, that can be a different issue, Your Lordship.
No, no.
My question
I don't see
before
any
Your
criminal
Lordship
case
is
here.
that Your
Mm.
Lordship may not lose out of the fact that his company was closed. That was not known to anyone except when his statement under investigation was given, Your Lordship. During the investigation, he disclosed that his company was closed. Therefore, I have given the authority before Your Lordship that from the very inception, he had the intention to cheat, and therefore his closure of the company was never revealed except
The
when
one
the
thing you must
investigation was-
remember, it is not he who approached you. It is you who approached. It is the
It's not my
complainant who
Your Lordship.
approached.
Even for Your Lordship will see.
No, no. I don't see there is any criminal
Your
case here.
Company
Discretion.
is closed according to the statement made by the petitioners on September 2022. September closure was there. And after that also, he has made.
September?
And this-
September, after September 2022 also, December he paid. See, December he paid.
Then
Where is the
payment
closure?
done. If his
Closure
company
is not
closed,
going to
if the
affect.
shop is
Closure, he
closed,
still says, he is still saying that closure will not affect. If the complainant still file a claiming with proper bills, he is ready to pay. Where is the criminal case?
If the company does not cheat from the very initial, I would not have never got into agreement. That's the point, Your Lordship.
If Your Lordship may allow, Your Lordship, I would like to submit
Mhm.
one judgment from this honorable court, Your Lordship.
What is this?
On similar lines, Your Lordship, this matter. On similar,
For the check bounce, you have a remedy under NIA.
For the check bounce case cannot be charged. It's a provision of the court that has to
My lord,
go to
in-
the magistrate.
in this case, Your Lordship, a case was registered under 468, 471, and 420, Your Lordship. And the complainant and the petitioner in this case, Your Lordship, they had a transaction of around 6 crore 25 lakhs, Your Lordship, without any written agreement, Your Lordship. However, this honorable court has interfered and has not, however, this honorable court has not interfered.
That is possible, but here is the case, there is an agreement.
That
On-
agreement is not there in the.
And we have.
This is verbal.
If there is no agreement and there was a cheating,
Yes.
naturally it's a criminal case, it will be.
Which is closed, gives a work order. Your Lordship will see that.
No, see. Miss Jenny, then additional PP, company is stated to have been closed in the September 22, but then thereafter also December paid.
That has to,
Where is the question of closure being affected to the transaction,
because we have
the business?
told about the closure. It was in the FIR, it was only when we came to know. That is the point, Your Lordship.
But payment Making.
Payment has to be made. You be in jail also, payment has to be made. That's a different-
Now also he's ready
Then your lordship may.
because you have
Then
not
your lordship
taken,
may say
the
this for
complainant has not taken proper steps to get his money back. If pay the bills, if there is any remaining bills back.
They,
Could have claimed.
they have stated
And then
that
if he failed to reply, and then thereafter closure, all those things make, he recourse to, and taken recourse to, then of course, different result would have been. But then here is a case, even after Ellie's closure of the company, he has made a payment. Now also ready.
they say that
You have not
they
made,
say that
make
we
a
have not,
proper approach.
they say that the complainant has not given a genuine bill.
No.
It's not
just
that
a
the
minute,
complainant has not given
Mm.
the bill. They say
See,
that we have not given the genuine bill. The claim-
We do not know the present status of the case also. And we may have to call for the present status. If it is the like end of the trial, we may not have to, of course, interfere with. Because if the evidence have already been closed or
No, evidence is not. It's still in appearance.
still in,
Appearance.
now what we can do is, see this, it appears that this is a civil case. But then since what he is now submitting is still he is ready to pay, why don't you make an approach, write a letter calculating and claiming the bills. This much amount is liable, and out of this much, sorry, this much was paid, and this much amount is liable, pay within 15 days, otherwise.
There's a small request I would like to
Mhm.
make to your lordship. Your lordship. I've just
And
seen,
then let them reply, let them deny, let us see.
yeah, I've just seen that,
Because case, we are not going to close there now at the moment.
I've just seen that my learned friend has the entire charge sheet, your lordship, which
Mhm.
is, which has not been annexed along, your lordship.
Mhm,
And we are finding hard it because there is no full record in the TCR also. Your lordship.
mhm.
If my friend have an entire charge sheet with him and he decides not to annex it along with the petition, I would request at least an additional file so that we can go through. There might have been a letter which I don't know, because now he have read a statement of the complainant which I'm not in privy to. So if he has, he can at least additional so that we can at least make an effort to see if this is.
So why entire, okay,
the-
entire, you have a latest record also.
Yes,
Okay, anyway, but then we can call for.
because
also.
it's difficult for us sometimes. The entire record is not there. My
Mhm.
friend has the entire charge sheet, your lordship. Now he is relying on the charge sheet. We are not able to look into it, your lordship. That's the-
No, no, it's
entire
not
petition-
latest.
Yes.
It's,
So any,
I have a very good certified copy of the charge sheet.
Hmm.
I have received.
charge sheet, I think it's available here.
yes,
Charge
because
sheet is available here,
then,
but
then,
not thereafter, I think.
yes, because it's.
So
very
what we can
difficult.
do,
It, why I'm saying that this, your
Hmm,
lordship, is
because what you
the
want,
entire record have this much of.
what the complainant want is the money back. Okay, your investment, whatever maybe. Okay, not the, probably the punishment. And of course, if you want punishment, that is a different issue instead of all those. But then, what we can do is we can call for the entire
Entire
scanned
record
copy of the records,
updated.
latest, updated record. And in the meantime, it is, because the case, even if the criminal case close also, if money transaction will remain, he is bound to pay if you are entitled. Okay, so in the meantime, because it is not going to affect the criminal case. Now also, referring to the submission, that you made a submission that still you are, the company is still alive. Okay, make a payment, this much amount.
Even
Make a
during,
claim.
even during the pendency, the parties can always come.
Yes, that is what I'm saying.
And file, in fact,
Hmm.
file a quashing together.
Sections. More 20.
Hmm. Otherwise, I don't see that this is, I think this is out and out civil case. So better take this recourse, and in the meantime, we'll call. If
Update.
any criminal case can be made out, let us see.
Yes.
Okay, but then in the meantime, if this can, we'll fix a little longer date. In the meantime, you make and then you reply. Let us see. If you are really intention to pay back. Okay. Hard, Mr. Yatso, Land Council for the petitioner. Also hard, Miss Jeannie, Land additional PP for the state. And Miss Land Council for respondent number? 2. Stop, huh? It is submitted that the trial court, the updated trial court report is not available in view of the, not available in view of the above, the call for the updated trial court record. Okay?
Your Lordship may fix this matter on 14th of September, Your Lordship, 14th of September.
We'll fix, give a long date. In the meantime, you take advantage of and write letter claiming, calculate, claim, give them some date, say around 15 days, let them reply. Okay,
The-
so as prayed for, as requested, come list the matter after 4 weeks.
After 4 weeks.
We'll say 4 weeks, okay? On a date to be fixed by the registry.
Item number 4.
TCR was called for, my lord.
Okay. It's a joint petition.
Yes.
What is the stage of the
Lordship,
trial?
trial is not started.
Not yet started.
Yes.
Cognizance taken.
No, Lordship. No, not yet.
Charge sheet filed.
Yes.
Yes, charge it.
Okay, so there is a stay.
Yes, my lord.
You have any objection?
No, my lord, if they have settled and stay is already there and my lord, they have settled, then there is a remote and bleak chance of conviction. So by applying-
They are relatives or
yes,
what?
my lord.
Relatives.
Yes,
Then we can dispose of.
yes, my lord. Applying the ratio laid down in Lakshmi Narayan.
Hard. Mr.
Yes, Tana.
Estana, Land Counsel for the petitioner. Petitioners.
Yes,
And
Lord.
this is joint,
Joint
Joint
petition.
petition.
okay, petitioners. How many petitioner? 2.
Two, my lord. One is the accused and two is the victim.
Okay. Petitioners, huh? Staff, huh? Also had Mr. Eugenie. No, sorry, is it Ete, huh? Land additional PP for the state staff. Para. This application under section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023 has been filed jointly by the informant. Petitioner number 1 is accused.
One is
The accused. Petitioner number 1 and the informant. Petitioner number 2. In Lemi PS case number. Praying for. Quashing of Lemi. In Lemi PS case number 2, 2026. Stop. The petitioners have jointly invoked the jurisdiction of this court under section 528 of the BNSS, seeking quashing of the said Lemmy PS case number. Quashing of the GR case, GR case. Where is the GR number?
In page number 2, my lord, GR case number 46 of 26. Page 2, course title, my lord.
Okay, GR case number 46, 2026, arising out of Lemmy PS case number 2, 2026, under section
Under section, my lord, 329(4),
329(4), 74 stroke 1152 stroke 351 2. Top, huh? Where is the FIR?
73 page number.
Okay.
Lordship, page number
The-
73 is FIR.
Okay. The brief case of the petitioner is leading to the filing of this application is that page 70
3.
FIR.
FIR page number 73.
Why it
Type
has
copy
gone
is
so
74,
far?
yeah.
Mm.
Lordship.
Based on the written FIR lodged by the petitioner number, the informant stroke petitioner number 2. The aforesaid Lemmy PS case number so and so was registered against the accused petitioner number 2 for criminal trespass, assault, intimidation, and threat. Also, has it been outraging the modesty also registered?
Yes, Lord.
Okay. Assault, criminal intimidation, outrage the modesty of women, and attempt to murder. Top, huh? Upon completion of investigation, the IO of the case submitted charge sheet for same offense
Yes.
under against the accused petitioner number 2 under section, where do we find same offense? Where do we find that charge sheet section?
Charge sheet will, my lord, will find in charge sheet, page number, my lord, 18, my lord.
18.
18 is the charge sheet, my lord.
Okay, where is the operative portion?
Operating portion is in, my lord, page number, 22, my lord. Hence, let me PS.
Yes, under section 329(4), 74, 115 to 351 to BNS. Stop, huh? And the case is presently pending before the which court?
SEPA CGM.
Chief Judicial Magistrate, SEPA. Process issued. Yes, no, thereafter state.
Yes, my lord.
Okay, not proceeded.
No,
Okay. Okay, the Honorable Counsel for the petitioner submits that during the pendency of the trial of the case come, the parties have amicably settled. Where is the settlement?
Page number, Lordship, 85.
Settled the matter by and executed a settlement agreement stroke compromise deed on 8/5/2026. Whereby the parties have agreed that in order to maintain cordial family relationship, the parties have settled the matter and the informant has no further grievance against the accused petitioner number 1, and she does not want to pursue with the matter any further. Okay. In view of the above, the learning counsel for the petitioner submits that since the party have already settled the matter and the matter involves with the personal, in the individual dispute, there is no chance of the of conviction in the case. Therefore, praise for praise for quashing of the proceeding against the accused petitioner. Okay. And then your submission also that there was no objection.
Yes, ma'am.
Since the parties have
Yes,
already
ma'am.
settled.
Remote and bleak chance of conviction. ma'am.
Okay. The learning council, the learning additional PP clearly submits that since the party have,
A relative also, ma'am.
but since the parties involved in the case are both relatives and they have amicably settled the matter
And to maintain cordial relation.
in order to maintain cordial relation between the parties. And as such, and in under the circumstances, there is a bleak chance of, a bleak and remote chance of conviction in the case. Therefore, he has no objection if the prayer of the petitioner is allowed. Okay.
Yes.
Okay. I'll dispose of, rest I'll dictate.
Obliged, ma'am.
Item number 6,
Hmm.
May it please, Lordship.
Yes.
Lordship, this dialysis accused person today, they have already spent 74 days in the custody. 74 days in the custody, Lordship, today. Lordship will find the FIR at page 18. And page 21 is the complaint. Lordship, is a very long FIR. In brief, it says that
Page 18.
page 18 FIR.
18 is FIR.
Yes,
Long FIR.
yes. Page, Lordship may come to page 21. There's a complaint left and right.
Okay. Mm-hmm.
May I read, Lordship?
Mm.
To the police officer in charge, Police Station Chokam, Namsai, subject FIR respected, Madam. Lordship, we have to be very.
So he is the brother, or how related he is with the informant or informant's husband?
Inform,
Brother,
yes, brother,
blood brother?
blood brother.
How it is possible, the blood brother
Yes,
committing such?
Lordship, actually, this way is, this, affair is little bit of, concocted because here we have, I helped them to establish a shop. For that, he had taken some loan amount from someone. Then again, he has also taken some loan amount from me also. Therefore, I serve him a notice, which is at annexure for page 23, legal notice.
When it was presented to the,
Yes,
when it was physically presented to the complainant?
on the legal notice is dated on 4th. It was delivered on 6th, and on the same day, FIR is lodged. That is why there is this allegation.
Do you have the receipt? That it
Uh,
was delivered and received on 6th?
on 6th delivery receipt. We do not have, but
Mm.
I think through AD they have checked, I think. It was delivered, but we could not take out the printout. It was on 6th only. It was physically delivered. I think it should have been there. But at present, we do not have. It was through internet, if you can see it,
Mm.
it delivers on 6th.
So ultimately charge sheet filed
Yes, a charge sheet file.
already on time.
On that,
Mm.
I think it's, we could not see that whether when the charge sheet was seen by the learned magistrate.
The statement of the victim as well as the child and then the surrounding neighbors, it appears that they are consistent.
Lordship, if statement of the independent witnesses also.
This cannot be encouraged, such people, such person.
Yes,
Yes, he need to be, because he is stated to be the powerful man, influential man.
no, Lordship. That's why,
Whether you applied bail before the trial court,
yes, Lordship.
rejected.
Rejected on the ground that I'm here nearby I stay nearby the victim's area.
Then what different view this court can take?
Now, Lordship, in one of the judgments, Sanjay Chandra, it says that if conditions are altered, that's why my respectful submission will be there. I will not stay near them, but I will stay within the jurisdiction of that POCSO court, and I will inform my new place of stay to the women PS as well as to the POCSO court also. I won't be near them. I will change my place of
Let the
stay.
trial court decide that.
No, Lordship, but here this is not that if we
No, because the statement of the others also,
yes.
it appears this person is a nuisance to the society. And he has not repented, realized.
Yes.
And then you see, if the blood brother, and then to the brother's daughter, it's very difficult.
Yes, Lordship, on that context, only two sections are non-bailable, 74 and 76.
Mm.
Both are punishment for up to 5 years. Now, recently, this Satinder Until was also interpreted
Mm.
that where they have to show that Lordship Mechanic 2026 Live Law SC 114.
Mm. What it says.
Lordship, here where the offense is of 7 years, then notice is mandatory, not the arrest. Arrest should be in a very exceptional cases, Lordship. Lordship may from para 18, it says that para 18 discusses about section 35(1) of BNSS. Section 35 1 surplus 1 of the BNSS 2023 through the use of the word may makes the
Para?
para 18 also,
Hmm.
makes the position of law rather clear that power of arrest is discretionary and optional. The power of arrest under section 35 clause 1A sub clause A to section 35 1 sub clause 1 J of the BNSS are distinct and different from each other.
Is it your pleader, pleaded case here in this?
Yes, Lordship, here.
Or whether this plea,
On the first instance in the earlier also that if Lordship we can take the bail rejection order also. Here also we have said that in the production state during the production also it was pleaded Lordship that below 7 years and all and ground of arrest is very generic. It was pleaded on the day of production also Lordship.
where have you stated in your petition? Let us see.
Since it was not considered at that time and we cannot review the order or that production order this way, we have not written here, but
Not in a petition. It's not your pleader case. Then it's on merit. But
Lordship,
then how do we reappreciate on merit? It was rejected on certain ground.
yes, Lordship, here,
How do we take a different view? It was rejected recently,
not recently, a month before.
month before.
Yes, during the investigation period. Now charge sheet has been filed, Lordship.
Hmm.
Now, what we have to see is that, Lordship, if we for
Now, what we can do? Yes, you have
we
anything to
can
submit?
have a strict condition that
Okay.
by saying that I will report to the women PS and to the POCSO court. As well.
We believe you, but we don't believe that this accused.
No, Lordship, it will be
His conduct,
yes.
it appears some
Lordship,
difficult.
for
Repeatedly he has done over and again,
Lordship,
and then not only to the mother, but also to the child,
no, Lordship,
who is his niece.
Lordship, that
Hmm.
that is not 100% correct because Lordship,
They are
here,
consistent, they are consistent.
that is why, Lordship, for fair trial,
Hmm.
we have a good reason to believe that this person will be acquitted. During the, I don't think so that they will stand a chance during the cross examination. That is why, Lordship, only for purpose of for fair trial, this bail during the during whole
Fair trial
investigation period.
in this
Lordship.
case can be done only if he is inside,
No, Lordship.
what we could see.
Lordship, here in Lordship, may I place one more judgment, Lordship? Here in the 2G spectrum case also, Lordship.
Those things are not going to help here in this case. Every
Yeah.
case has a different, you see, fact and circumstances.
Yes, Lordship.
We could understand what could be, what or would be the result
Yes,
of his bail.
Lordship, that's why for
We
limited
can
purpose only.
direct the trial courts to expedite.
Lordship, if
And then after recording of the evidence of the victim, the bail you can always approach for bail, can release. But then
Lordship,
until
Lordship, during if
he is a very powerful and he took
Lordship, if
advantage.
suppo-
He forgot his brother also, and then he didn't care about, never care about his brother.
Lordship, we have
Take,
here
took,
that's
took
why
advantage of his absence.
Lordship, they have concocted the story in a such a way
What is the
not
reason?
to, not to get. The reason is, Lordship, that is why they have taken loan and they are not
Why
willing
they
to
would
repay.
concord? Why they would concord the story against you?
That's why, Lordship, the annexer for
Why you had to be there in absence of your brother? Okay. Yes, you have anything to submit?
My lord, material, my lord, perhaps my lord has perused the record, my lord, the
I've
statement.
just seen.
Yes, my
few
lord. So
statements.
far as my lord, the POCSO offense is concerned,
Hmm.
my lord, there is no sufficient incriminating material, but to substantiate the other sections.
POCSO because why?
Recorded the statement, either directed to withdraw the FIR. I don't know what exactly IO has
Maybe
is
there,
minor, minor.
maybe there is nothing against them
Oh.
because
Don't-
the
Then-
they have
then,
not been.
When do we
it-
fix then?
After a week, Your Lordship.
Okay.
Because on the even on the last occasion when the matter had come up, it on the same date the trial court has the had the CD. Your Lordship. We have just spoken to the IO. He had stated that until unless that does not release the CD from the magistrate's court, he won't be able to produce it before us.
Which court?
This is the court of. I think this is JMFC. JMFC should be
Okay. Miss-
UPI. Your Lordship.
Okay. Miss Nya, JTK, Land Council for the petitioner, stop. Miss Tijini, Land Edison PP. Submit that the case record, no, it's a case
The
record.
CD. Your Lordship.
Okay, it's a CD.
Yes. Your Lordship.
Sorry. Submitted that the case diary. We stated to have not yet received back from the concern, the judicial magistrate first class, due to which the same could not be produced today. So therefore, she prays for the 1 week time. And the prayer is allowed. Is requested, list the matter after a week. We'll say after a week,
Yes. Yes. Your
After-
Lordship.
okay.
If Your Lordship.
on which date the land additional PP shall produce the updated case diary.
Third of
On
Scan
September.
copy of updated
On
case
3rd
diary.
of September.
Okay, third.
In the meantime, my lord, the interim kindly.
The interim order passed earlier shall continue till then. Okay.
Grateful.
Deeply.
Good. Yes.
7 and 8 are connected, Lordship.
Yes.
Item number
Finish
9.
the 7 and 8, huh? We'll try to finish, and that's why,
Item number 9, Your Lordship, the service has not been completed upon respondent number 2.
Mm-hmm. Mr.
Bitaba, Lordship.
Land Council. B,
Bitaba.
sorry, Land Council for the petitioner. The service report upon the respondent number 2 is still awaited. Also had Miss Cheney, Land additional PP for the state.
In the
Service report,
meantime, interim may be allowed, sir. Continue, sir.
in respect of the respondent number 2 is still awaited. Staff, in view of the above, list the matter after. What is this, criminal petition?
Criminal petition, sir.
After a week,
After a
After
week.
we,
after a week, okay. What interim order was passed here?
For stay of proceeding, Lordship. The matter is fixed before JFC.
In the meantime, the interim order passed earlier shall continue till the next date of listing. Okay.
Deep-
Item number 11.
my lord, same order in item number 8 also. Similar to 7.
A similar order,
Your Lordship, this joint petition, Lordship, this can be disposed of.
11,
Yes, Lordship. Between husband and wife, Lordship.
husband and wife.
Yes, Lordship. 489.
PCR आ गया. PCR आ गया.
Page number 17 is the FIR, Lordship.
The fire is at page
Page
7,
number 16, Lordship.
16.
Yes, Lordship. This basically the FIR is filed by the victim, who is the wife of the accused.
Mr. Ete will be able to tell whether it can be disposed of.
Yes, madam.
My lord, TCR received, my lord.
Okay.
TCR
Is
was,
there any material which cannot be, which according to you cannot be disposed of?
my lord, if TCR is received and they have settled, my lord, and now we have to look into the my lord, the offenses, whether it will fall under the guidelines laid down by the Supreme Court or not, my
It's
lord.
against a third party, I think. Causing trouble.
And FIR has to be looked into, my lord.
Yes. So says that causing marital dispute between me and my husband. So someone is there to disturb,
Yes, third person.
causing some trouble to them.
Yes.
So it will be difficult,
Your sip-
difficult to prove also, I think. And then since the party has entered into agreement,
agreement and
settled,
settled there.
already settled, then they have already,
Yes, my lord.
Living-
It's a husband and one lady, my lord. The name
yes, it's against the lady only,
is-
not against the husband even.
yes, my lord. And lady, my lord, no offense can be considered against this lady to having an
Yes.
affair with the lady.
Yes, cannot be.
Yes, my lord.
Not possible, sir.
Not possible.
On merit also.
Yes, my lord.
It will be difficult. Then I think we'll
Yes.
dispose of.
Yes.
Okay.
Yes.
Hard, Mr.
Taba.
Taba, Learning Council. Okay, let us just, let me record that. Learning Council for the petitioner. Also, Mr. Theatre, Learning Edition PP for the state. Okay, this is this application has been filed jointly by who is the accused?
Accused is Nabum Natum.
Petitioner number one.
One is the accused person.
Accused and similar, huh? And informant, petitioner number two. In which PS case?
It's
Data PS case number
the PS.
60, 2018. That's tough, huh? Both the petitioner number one and two, the accused petitioner number one and the informant petitioner number two have jointly filed this application, praying for quashing of the GR case number 491, 2018, arising out of ITA WPS number 60, 2018 under section 498A of IPC, pending before the Court of Judicial Magistrates First Class, UPA. Stop, huh? The case of the petitioners is that on 9/7/2018, the petitioner number two lodged a written FIR before the officer in charge, Women PS Police Station, Itanagar, alleging no. Who is the informant? Tanalipi. Who is the accused?
Accused is Nabum Natung, petition number one.
Accused is a male.
Male, yes.
Allegation by the wife against the husband to having an illicit relationship with other women, and because of that, she was subjected to torture,
Yes.
cruelty.
Okay.
That is the allegation.
Alleging her husband, petitioner number one, for subjecting her cruelty. Any other allegations?
An appearance is there.
Affair is there.
Having an
And keeping a
illicit appearance with
illicit relationship with another woman. Stop, huh? Based on the said written FIR, the aforementioned with a women PS case number 6018 was registered and investigated into. Stop, huh? Upon charge sheet filed, completion of investigation, the IE of the case laid charge sheet against accused applicant number one, accused applicant number one for offense under section
498, capital A.
and capital A.
Yes.
And what? Only 498
Only
A.
498. Yes.
498.
Only this, in
Yeah,
additional
yeah.
affidavit, page number 47.
Page 47.
Yes, in additional affidavit.
Critical affidavit.
Prohibitions order, madam.
Okay, A 498 within bracket capital A IPC, huh? So court taken cognizance
Yes, sir. Cognizance has been taken also.
and then charge prime? No,
Charge.
it was cognizance taken way back 2025.
And
What is the state?
and thereafter, this
is
honorable
for
court
the-
has granted stay in this case also.
Hmm?
There was a stay in this case.
Say when?
January.
In
No, just a minute, huh? 16/6/26, nothing taken up here is under transfer.
28
This is
January
someone-
26, there was stay.
Consent was directed.
6, 10, 20, after that.
We'll find in page number 33 years. Fixed 11 to 26 for appearance. Annexer 3, madam.
Like that, right?
Yes, my lord.
And the record.
16, 10,
Page
25.
30?
33, my lord, in main petition. Charge, perhaps charges, not.
610.
Yes, my lord. 16, 10, 25.
No, thereafter 16/6/26 also there. He is fixing for appearance. Then thereafter, I think there is
It's
some
fixing on 11, 2, 2026 for appearance.
426 case no is trying to and so. The forward court
Be-
GMFC
Before
transfer to some other case, some other court. And deciding of this redo.
Before it was stayed. Before 11, 2, 26, my lord, the matter has been stayed, my lord.
11?
2, 2026, my lord, will find in page 33, where my lord, on 16, 10, 25, the matter has again fixed on 11, 2, 26.
Okay.
And in between, my lord, the matter has been stayed, my lord.
Is it?
Yes, my lord. The matter
Thereafter,
was
probably the court didn't know. So this order after 11/2, then 2/4 also case record put up. There was the instant case record we forwarded to the JMFC Vidopina for trial. And 16/6 also order passed. Case fixed for appearance again.
perhaps, my lord, done a trial,
Probably
is not
the
aware of this.
order was not furnished. Brought into notice of the court probably. Art again is present. This matter could not be taken up. PO is under transfer. Issue summon notice. Concern was directed to submit a execution compliance report for appearance. 31/8 this month. Fixed for appearance.
Perhaps the done a trial court is not aware of the.
But then it's the duty of the petitioner
Yes, my lord.
to bring on record or to
they have-
furnish a copy of the
Yes, my lord. They have to file
certified
actually
copy of the order.
miscellaneous
Stay order.
application, my lord, before the trial.
Where is the stay?
Space
Till the next returnable date.
20,
The
21.
proceeding of GR case number so and so for JMFC popular sale remains stayed. Remains suspended. It was in yes, but then thereafter also proceeded. But see, after obtaining copy or certified copy of the order of the High Court, it's a duty of the advocate to forward it before the court, submit it, saying that on the next date fixed, sincerely appear and apprise the court that it has been stayed, not to proceed with. Unless it is informed, the court will proceed. And in that case, there will be misunderstanding.
Yes, ma'am. Possibility of issuing non-bailable warrant also.
So that is why it says that execution compliance. OC is directed to submit the execution compliance.
It means,
Means
my lord,
non-bailable-
bailable warrant has been issued. already.
See, we have to be a little bit sincere. Some order obtained, no need, they will understand. Don't be under such impression, no? Okay, then pending before the judicial magistrate first class, no? This, they have not mentioned judicial magistrate first class, which one? Because there are different cases, different, they should also mention, the magistrate should also mention. Which judicial magistrate first class, I'm told that there is 3 judicial magistrate
Yes,
first
sir.
class.
Yes, my magistrate. This is, I think, 3. 3, no, 2.
They have not mentioned, they should actually specify. Because instead of 1 judicial magistrate first class, it will go to some other court again. If it goes from to registry.
Yes, madam.
But
Perhaps
that's why
it will be some other.
the concerned advocate has to
Yes, madam.
actually apprise.
It's the best, my lord, if they file an appropriate misapplication
Mhm.
to bring it into record.
Yes.
An order need to be passed by the magistrate itself, madam, to bring it into the record.
Charge is submitted on 0498, pending before the judicial magistrate first class. Staff, it is submitted that during the pendency of the, when it was settled,
On
Where is that?
And page number 36 also,
36.
starting from page 35 also.
Oh.
Yes. 6 January 20.
Pendency of the case, the party being, they are relative or just party?
This, they are husband and wife. Also.
Okay, no, husband and wife, party being the husband and wife, have amicably settled the matter. And wherein the wife has categorically stated that since the matter has been settled, she has no further grievances against the accused husband, and she does not want to pursue with the matter any further. Okay, so the similar order will pass, and yours also. Okay,
Yes, ma'am.
we'll finish it.
Obliged. Much obliged, sir.
Item number 12. This is item 11, no?
Settlement.
Mm.
This is also settlement.
Yes, 12.
This is also settlement, my lord, since this year is not yet received.
Okay,
Then await for the TCR, ma'am.
okay.
This is also husband-wife dispute.
Heard Mr. Kudu, Lana Council for the petitioner. Also heard Mr. Yete Lana additional PP for the state. So the trial court record is called for, is still awaited in view of the above. Issue reminders to the, which court?
JFC UPR.
Number
two.
Issue and the registry shall issue reminder for the scanned copy of the trial court record from the judicial magistrates first class.
Two.
Okay.
Yeah.
List the matter after 1 week, 2 weeks.
1 week, my lord.
Okay, then list the matter after a week. Okay.
Interim is here, madam.
The interim order pass earlier shall continue till the
Obliged.
till the next date of listing. Okay. Yes.
Item number 13 and 14.
The trial court record received,
Yes,
this can be listed for admission.
My lord,
We'll try to dispose of in the admission stage.
that can also be done, my lord. I'm only agree with I filed an IA application, my lord,
IA for what?
for vacation of the interim order, my lord.
Vacation.
Yes. There was an interim order.
Okay, interim for what?
Yeah.
In people of the order 15/6/2026 passed by the secretary, which I am challenging in the CRP.
Page 7 of my IA, my lord.
No, just a minute, huh? Interim order was passed in which case?
Interim order was.
CRP.
2/7.
In this case, 137.
137. What interim order was passed?
Interim order was passed.
In the meantime, the operation of the.
Operation of-
What is this order, 15/6?
15/6, the order which I have, that is in challenge in CRP 58, the order. By that order, my applications were dismissed and they were allowed to file appeal with a condonation application. My challenge was that that cannot be done when notice was issued to me. That has to be done before the notice under order 41. That
Just a minute, huh?
detailed hearing is required in this. The matter may be fixed for hearing, Your Honor. I may file reply to this application.
Okay. Your interlocutory application for rejection of the appeal was
Yes,
dismissed.
dismissed.
Okay, so according to you, it was it amount to permission to the applicant to cure the defect.
Yes.
Okay.
In fact, this letter, my lord, dates back to 2015, my lord. In fact,
Okay.
There was a Kabang, my lord. However, when Kabang was collected on 1/10/2015, my lord. Then the then DSC was did not pass the order, my lord.
Okay.
On the same day, my lord.
It was, okay,
And-
those era.
Yes, but
Ah.
it was not passed, my lord.
Uh-huh.
Now, and it was dispatched on 27/11/2015, my lord.
Hmm.
Order was dispatched to the, here, the respondents, my lord. And we received it on 5/12/2015, and the appeals were preferred before the Deputy Commissioner on 17/12/2015, 28/12/2015, and 1/4/1/2016. However, my lord, in the order, even if it was displayed, in the order it is done 1/10/2015, but on that day that order was not passed.
Okay.
Therefore,
So,
my lord, when the application was filed before the Deputy Commissioner, my lord, we were of the impression that since it was the poll act, my lord, under the my lord, so no application for condemnation of delay was filed.
Okay, okay.
2016, my lord.
Okay, that complication, then we'll here,
Detailed hearing is required in this
we'll fix it for admission.
admission hearing.
Okay. Mr. Pada, Learning Counsel for the applicant.
No, yes, my lord. No.
In the applicant, IA, the IA is listed first, I think.
Yes, my lord. Yes.
Okay. Also had Mr. DK there, their Learning Counsel appearing on the of the opposite party petitioner staff. Okay. Since the parties are duly represented and the trial court record has also been received, let this matter be listed for admission. One,
Can it be on 10th of September?
as requested, list matter on 10th. 10th.
10. 10 is when?
10 is Thursday, is a DB day. Can be on 9 or 16, any day.
16,
9 I have already met.
16.
16, okay.
Item number 16.
Your Honor, here interim stay to be continued.
In which? Okay,
IA
the
130.
interim order passed in 137. IA seat 137 shall continue till the next date of listing. Okay.
Obvious.
Item number 16
16 is also there.
is unlisted motion matter.
Unlisted, look. Okay. This was for what?
Well, this is also settled on earlier, she already filed and withdrawn, there was some error. And now they have annexed the cognizance order also, madam.
Then petition, father and the son of the.
Okay.
Earlier I had already filed, but due to the error.
Only because of the error.
Yes, yes.
So a father and son,
Father and son.
you had no objection, I think.
Yes, madam. No, no objection, madam.
So what we can, otherwise the entire, we'll just record this one and necessary particles, huh?
Yes, ma'am.
Particulars, huh? Had Miss
B memo.
Learning Counsel for the petitioner, also had Mr. Learning additional PP for the state staff, huh? Same, huh? This application has been filed, this application under section 528 BNSS 2023 has been filed jointly by the who is the father? Who is the okay? Father is one. Okay, the accused and sorry, the informant and accused. In where the PS case number have where have you mentioned PS case? Palin PS case, PLN, Palin PS case number 05/2026. And what is this PR case?
PR, my lord, the magistrate out there, he is just started to practice to identify it's a Palin registered case, my lord. Instead of GR, he has written his
Okay, this
Actually,
Yeah.
earlier the magistrate who was proceeding the case, Lord, he by evidently he entered as a PR case. So from there, it's continued as a PR case.
okay. It should be a government register. Okay?
yes,
Yes,
normally
government-
GR, it should be GR actually.
GR. All over India, it's GR.
Yes, my lord.
Palin has changed.
And if they wanted to, my lord, for better, my lord, to identify, then supposed to they write GR bracket PR, so as to identify the location.
If they want.
Yes,
Huh?
ma'am.
Okay.
That confuse everyone, madam.
Leave that, huh? Stop, huh? But the there are the informant petitioner number 1 and the accused petitioner number. The informant petitioner number 1 is the father and the accused petitioner number 2 is the son. They have jointly filed this application under section 528, bring for crossing of the GR case number, PR case number. It's awkward to record PR case because it doesn't reflect the GR case, no? PR case number 05/2026 arising out of the filing PS case number 05/2026 under section 331 to 335 to 324 3 BNS 2023 staff the the case of the petitioners is that based on the FIR lodged by the informant petitioner number 1 against petitioner number, where is the FIR?
FIR is page number.
Okay. Against accused petitioner number 2, who is the son, who is his own son, alleging for threatening and damaging of the property, threatening, damaging of the property and trespass, the aforesaid filing PS case number was registered and investigated into stuff. Charge sheet filed.
Yes, Lord.
Upon completion of investigation, the police has submitted charge sheet into the case against the accused petitioner number 2 for offense under section.
The lordship matter is fixed for CC today.
Okay, section so and so, and matter is pending before which court? Judicial magistrate,
Judicial magistrate, first class filing.
first class filing, staff, It is, then the Rani Council for the petitioner submitted during the pendency of the case, the petitioners being father and son has amicably settled the matter in order to maintain their relationship as father and son and executed where is the
71 and it's 5.
71 settlement deeds dated 71 10/8/2026, whereby the informant father has categorically stated that he has no further grievance against the accused petitioner number 2 and he does not wish to pursue with the matter any further. In view of the above, the Rani Council for the petitioner submits that since the accused and the informant are father and son, and the matter has amicably been settled between them, there is a remote chance of misconviction in the case. Therefore, she prays that the proceeding against the accused petitioner number 2 be set aside and passed. Okay. Similar order it will become.
Obliged, man. Dispose of, my lord, this matter.
Dispose.
Yes, ma'am.
Okay.
Obliged, man.